Hello and welcome to the docket presented by Defense Diaries. I am your host, Bob Mata, and I am joined by my beautiful, brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, y'all.
Hey, guys. All right, so I want to take a few minutes, let people drip in here. So what's going on? What's good?
I don't know. I was just reading through some of those recent filings, wondering, hey, can you hear me?
I can hear you like an angel just like floated down from heaven and whispered in my ear. Yeah, I can hear you. I can hear you perfectly. Oh, I see you've gone back to your black headphones.
Yep.
Wait, like people were like, "Oh, I need Allie to put a link up for those dope blue headphones you were wearing yesterday." Man, dude, it's like you are so obstinate about like I bought like the nicest two sets of headphones. I got a white pair and a super cool like aquamarine or maybe teal. I don't know. Like they're super dope. Like I just don't get why, and they're way more comfortable. Like those things that you have on have no padding. I just can't do it. They hurt my ears every time I put them on. Like I was wearing them the other day because you had them plugged in when I was recording the Garcia episode, and like an hour in, like my ears are like killing me. Of course, I do have pretty big jug handles, so that might.
No, you don't.
You have dainty little ears.
Okay.
All right, so a couple things going on tonight. I have Bill Dorsch joining me again. We're not doing Gacy tonight, though. In anticipation of next Tuesday night, we are having documentary filmmaker Margaret Byrne, who has been following and documenting the Reynaldo Guevara nightmare, the worst cop ever that no one's ever heard about. Like it's a story that I just can't believe everyone in the country hasn't heard about. Like this dude, like literally, like in the 90s, closed 50 plus cold case homicides in the city of Chicago.
Well, the 90s. This was going on with him well past the 90s.
I think it was all through the 90s.
It was
everyone did like 20 years.
I mean, I'm just saying it's well past that as well. I mean, like I said, I've been doing research on corruption in Chicago, so all his cases have been coming up.
Like recently?
Yeah.
No, nothing in the like the 20s. Well, we'll find out tonight through Bill Dorsch.
Right.
So, but it started in the 90s, and he closed like 50 plus. Like as soon as Bill whistle blew on him, it was over. Like there was no more of it.
Seen his affidavit is attached to pleadings and cases. I'm telling you.
Okay. Are you sure you're not thinking of Burge and his crew?
I'm positive.
Okay. So
not positive on the dates. I'm positive of who I'm thinking of. I think I'm sure on the dates.
I mean, he could have been going in the early 2000s, but like these dudes all do, like we're doing 15, 20 years, like when they got exonerated. So at any rate, 50 plus cold cases, Chicago homicides, all closed. You know, he's the hero. I'm the hero. I'm the greatest cop of all time. Turns out that every single one of them was fixed. All of them were all crooked. Every single one of those people that got convicted, went through the trial process, were convicted, served a bulk, if not all of their sentences, 20, 25 years on homicides. Been like 41 of them have been exonerated. Chicago is paying out $5, $10, $20 million per exoneree. This dude's unbelievable. So tonight, Bill and I are going to give you all a primer. I'll try to get some more accurate dates from Bill because he'll be the dude who knows. And then next week, as I said, we're going to have Margaret Byrne on. She really has spent a huge amount of time interviewing the exonerees and their families and the experience of what that was like for them and getting like just like that side of the story, which I think it's going to be super compelling. Anybody who gives a shit about justice should be watching it, and hopefully you'll share it and you'll tell people about it because it's a pretty unbelievable story. It really, really is. And Bill was the whistleblower. I mean, Bill Dorsch, for those of you that don't know, dude's a badass, and he was a Chicago cop for 20 plus years till they ran him out of the country, literally, because he was the whistleblower on Guevara. So just let that sink in. And you know, it's an incredible story. So, all right, back to the task at hand here. We had some filings, we had some orders dropped today. Nothing relating to the most recent hearings with respect to the orders. All right. So let's just go through those first because they're the easiest to get through. And I'm like, I'll just tell you flat out, I'm not surprised, but we'll discuss whether or not we think it was the right legal decision. I don't know. All right. So this was the order that dropped say the 12th or the 13th. So this dropped yesterday, or at least it was entered into the system. It's dated today. Gull signed off on it yesterday. So it's basically order or judgment of the court. The court having had Richard Allen's third Frank's notice and request for Frank's hearing based upon newly discovered evidence and request for findings of facts and conclusions of law upon any ruling on this request filed March 13th of 2024. The state's response to the defense's third motion for Frank's hearing filed April 3, 2024, and the defense's reply to the prosecution's response to the third Frank's memorandum filed April 5, 2024 under advisement now denies the third request for a Frank's hearing without hearing. The court finds that the affidavit submitted in support of the issuance of the search warrant contained information that a reasonable belief existed that evidence of the murders would be found in the defendant's vehicles and home. The affidavit did not contain false statements, nor did the affiant omit statutes with reckless disregard. Further, the court does not find the affiant intended to mislead the judge by failing to present relevant information. So there's Frank's 3 flushed straight down the toilet. And you and I, over the course of the last year, have been somewhat critical about the Franks being used for what is essentially a suppression motion. Like this could have been a straight suppression motion. I guess my question for you is, had it been just a straight up suppression motion, does anything change though? I mean, they got out all their narrative that they wanted to get out about, you know, the third party culprits, which I think was ultimately the goal of the Franks memo, you know, but like the heart of it was really a suppression motion, you know, and I mean, they took the route saying that Liggett had lied about certain things or omitted certain things. And that was the grounds by which they should suppress the evidence, because that's what they were seeking to do, really, was to suppress the fruits of that search, which essentially are the gun, you know, whatever clothes. It would have been his devices as well, anything that they got from the house and the cars, if they found anything in the cars. So, I mean, what's your opinion on it?
I mean, it's probably at the end of the day would have been the same. I mean, I think it would have been better to focus on the strongest points. Were there some that, to tell you the truth, I can't even remember anymore what were the strongest points. I just think that they should have challenged um the bullet findings, the casing results, because that was, I thought, one of the main points of their search warrant, that they were searching for that because there was this match, so to say. So I don't know why. I did think at some point that they were doing that. I can't remember. Maybe you do. That it was something like they had filed or put out there or something. Um,
Yeah, they had filed something early on that was a suppression motion relating to that issue. They got converted.
right,
They
to a
withdrew
bond.
it. Yeah, well, it was the bail application thing where they were basically going in arguing that the evidence that they had was weak and that, you know, he should be given a bond.
And
So, but
that's where I thought a lot of these facts could have come in, because that it is relevant that there's other potential suspects, that there's all these other things like pointing to other people, pointing to other timelines, da 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 da. Like all that could go to show that the evidence is not, very strong. That could be grounds to maybe argue for his pretrial release.
yeah, yeah, I don't know. I don't know. And like ultimately that thing, because I remember I was driving down, that was what turned out to be the first safekeeping hearing. That was last June. Remember, I was really excited. I was like, oh my God, I'm finally going to get to hear some actual
Hmm.
facts about the case. You know, this is going to be amazing. It's going to be like a little mini trial. And then it wasn't. It was the safekeeping thing. In terms of why that thing was, you know, why they withdrew that particular motion, I don't
Travis
know.
said they ruled. Travis says they ruled on it. I got Tavis on my mind.
Oh, did you say Tavis?
Yeah.
He's
We
from
have
our
a friend,
friend.
Tavis.
This is his band, Houseplant. So yeah, well, they challenged it, but not in the way that I would expect. And obviously, at that point, they hadn't hired, when that motion was filed, they hadn't hired any kind of expert.
Yeah, I didn't remember any sort of expert attack on it
Yeah,
establishing that,
I
but
think
maybe they did some research and realized it's gonna be a question of weight or fact or something. I don't
but
know.
it's definitely going to be weight. In Indiana, it goes to weight, not admissibility. So, I mean, that thing was coming in, you know, because they don't really follow strictly either Fry.
Dahlberg or Fry.
Yeah, you know, so
Alright, so move on to
all
your
right.
next.
Okay, so second order drops. Again, this one dropped today proper. Another order of judgment of the court having had defendant Richard Allen's fourth Frank's motion based on newly discovered evidence and request for hearing filed April 29, 2024, and the state's response to defense's fourth motion for Frank's hearing filed May 17th, 2024, and the defendant's reply to the state's response to the defense's fourth motion for Frank's hearing and request for hearing for reasons detailed herein, filed July 23rd of 2024, now denies the same without hearing. The court is obligated to conduct a Frank's hearing only if the defendant makes a preliminary showing that the affiant knowingly or intentionally or with reckless disregard for the truth included a false statement in the search warrant affidavit, and that the allegedly false statement was necessary to a finding of probable cause. The defense has not made such a preliminary showing and therefore is not entitled to a Frank's hearing.
It seems like from her argument there that she doesn't believe you're entitled to a Frank's hearing if they had established, I'm not saying they have, but if they had established that they omitted facts such that the affidavit was misleading.
Yeah, I mean, look, here's the thing. Like, she's now ruled on these after we've had the 3 days of hearing, and namely the third day, which was the state's motion in limine seeking to limit or exclude them from being able to, which we'll get into because the defense filed a supplemental filing today, where the state was seeking to basically exclude third party culprit stuff. So, you know, my point being, now she's heard it all. So the defense put their best foot forward that they could at that point in time with respect to, you know, an expert witness in atypical crime scenes and ritualistic murders. And then they had, you know, a few other witnesses. They had Click there. They had Kevin Murphy there. Both those guys testified, you know, and a lot of it was like Kevin Murphy's testimony was new. We had not seen Kevin testify. He ended up testifying 2 out of the 3 days there because they called him up twice. His testimony was substantially similar on the third day. As I talked about during that hearing, that's when he kind of broke down when he saw the photographs of the girls, crime scene photos, you know, and he got visibly upset on the stand. And you know, I mean, I wouldn't call it backtracking, but like, I mean, they had to answer the questions honestly, which ultimately are really why none of these guys, these 5 guys, ever were arrested. They couldn't put any of those guys at the scene. They couldn't put them in Delphi. They couldn't put them on the bridge. Like, you know, like how much they dug into that is really what is going to be at issue, I think, at trial, you know, because there's the inadequacy of the investigation aspect that that goes hand in hand with the third party culprit defense theory. You know, I mean, I don't know what they did in terms of trying to blow apart Holder's alibi, but as I've said, like, and I maintain this position that the key to this case, in terms of getting to the truth, and whether if Allen's the guy, then he's the guy, but we need to figure out when the girls were killed. And the state is now locked in on the record, locked in to the girls died between 2:30 and 3:30, not 4:30. 2:30 and 3:30 is the testimony that they believe in which the girls met their demise. That's it. That's it. That they're locked in there. So, you know, the things that came out in that hearing that we're going to find out about at trial and get more in depth into is that they didn't get body temps off either of the girls at the time. And there's no time of death. Like, so the ME failed miserably in terms of doing what they could to determine when this may have happened. And then you inject in this concept of the phone either turning on or powering back up at 4:33 a.m., wherein 14 or 15 messages come into Libby's phone inexplicably. And I need everyone to know I am actively, Allie and I are both, I'm actively finding, I'm going to find an absolutely kick-ass, like, hopefully former Fed who's a forensic phone person to explain that to all of us, including me, like I'm a 5-year-old, how that happens. Because we know that AT&T was pinging that phone every 15 minutes. It's inexplicable to me that that phone was on and just not connecting to the tower for 11 hours. I'm not buying it. So, which means that that phone came on or somebody turned it on. And I want to know if that's explainable any other way than the phone being turned on by a human being at 4:33 in the morning,
or repositioned to a place that had signal,
or right, or comes back, or the phone comes back into an area where it's hitting that tower. I mean, there are not many towers in Delphi. I don't know. It's 1 or 2, maybe 3. I don't know. So I'd be speculating as to how many towers are there. But if you're taking that access road out, because Auger had made the argument there when she had Cecil, who was their phone guy, Indiana's phone guy, the state's phone guy, and was trying to get him to commit to the fact that whatever the Apple Health data showed with respect to the amount of steps, that amount of steps could have equated to a car lying in wait on the access road that was down there, and the girls could have been ushered directly into the vehicle and driven away from where they were ultimately discovered. And whatever takes place over the next 11 hours, and then the vehicle under cover of darkness comes in through that third access road, which is not caught on the camera over at the Hoosier Harvester or whatever that store's called. And
so what does that mean then? They turned off the phone to do all those things and then turned it back on?
If I were taking the girls off property, like away from where I abducted them, I would certainly turn their phone off. Wouldn't you?
Then it seems the only reason you turn it back on is if you wanted them found. some sense of guilt.
Correct. Some sense of something. I mean, the phone was clearly like that's the other part of this. Like, why leave the phone at all?
Right.
You know, like, I mean, clearly the killer or killers know that the phone exists because it's found like either
Out.
in her shoe or under her shoe, under Libby's body. Like it was certainly placed there intentionally. So whether that was okay, we want people to find the girls, but we want them to find them now. You know, because the other thing that I keep like screaming about is I'm like if you and I are handling this case and we had our private investigator Steve Yonke working it, I am every day on the phone with him saying, dude, okay, there were hundreds of civilian searchers. You need to find one that was down the 200 yards where the
I
girls were
am
discovered.
sure they're trying to find all the civilian searchers that they can.
I would hope so. I would hope so, because to me, that's the key to the case. That's the key to getting to it. Now, does that mean that like if it's still Richard Allen, so let's assume that it's still Richard Allen. Okay, so it's Richard Allen that took them from the area, removed them from the area, found some kind of private place to do all these horrible things to the girls, and then drove back. Like, at that point, like, wouldn't Kathy have been aware that he was not home all night? Like, you would certainly be aware of me being out till 4:30 in the morning.
What?
You know,
Of course. Is there oh, it was 4:30 in the morning that the phone went back on.
yes, 4:30
Oh.
a.m. What time did you think I was about? 4:30
I don't know.
in the
I
afternoon?
it's hard to keep
Holy
track of
shit,
all
that's
this
like
stuff.
night and day, bro. Wow. Yeah, no, 4:30 a.m., 11 hours. 11 hours later from the last any kind of connection or any kind of action from that phone, which I think was, don't quote me on it, but like 5:45, maybe 5:47, sometime like that was the last thing that like came into Libby's phone, and then nothing until 4:33 a.m. So
Crazy. All right, so just to circle back to the Frank's motions. I know a lot of people are upset. How's the judge do this without a hearing? But the Frank's motion is one of those motions that she's supposed to decide, and in theory, taking everything and believing everything that the defense says as accurate, as truthful. Is there enough there to change the warrant? Was there enough either withheld or, you know, lies? And I do remember there were a bunch of changes about what witnesses saw, what time they saw them, what they were wearing, things like that. But in any event, the judge has, in her opinion, decided that even if all of this stuff is true, I don't think it changes the warrant. So that's why she doesn't need to have a hearing, because like I'm saying, technically in her mind, the exercise she's doing right now is if all of the things they said were accurate, um, maybe this witness said this instead of this, or they said it this way instead of that way, and X, Y, and Z, does that change whether or not there was probable cause to support the search? She found no. So having a hearing wouldn't change her opinion if she's, like I said, kind of doing the exercise right. Assuming all this stuff is true, do I still think that there was enough for a warrant?
all right, so let me throw this ponderable at you. What about the fact that there now exists, and I don't care what McClelland's saying, because every other law enforcement person that I've read and every article that I've read about geofence data is that it's exceptionally reliable. And like McClelland sitting there in open court saying that it's hot garbage, that we'll never use it in order to secure a warrant. Like, he's trashed that technology for Delphi and like Carroll County Sheriff forever. Like, they'll never be able to use it because they'll always go back to that hearing. They'll order that transcript and they'll say, oh, well, Nick, do you remember when you said this was hot garbage? You can't have it both ways, buddy. So, but my question to you is, in light of the fact that we now have geofencing data that shows that there were 3 to 4 phones in that area around the time that the girls are abducted, okay? And we have Libby's phone turning on at 4:33 a.m. which changes theoretically, at least theoretically, changes the timeline, the time of death, or where the girls were killed, or like, I mean, like, take those into consideration.
If I take them into consideration for the search warrant, I think that the end result could be the same, because she's saying, all right, well, maybe all those are possibilities, but this is one possibility that they've kind of built up, and I think it warranted a search. Doesn't change whether there's all these other possibilities. Right or wrong,
Yeah, I don't know. I mean, look, the fact of the matter is, the reality is, defense lawyers don't typically prevail on motions to suppress unless you have a smoking gun constitutional violation. That's it. Like, I mean, that's the reality, not just with Judge Gull, but with every judge. Like, you don't walk in winning these motions left and right. We lose
not
them
even left or
way.
right.
Yeah. I mean, like, we lose them constantly when we think that we have great grounds, like, all the time. Like, Allison's written, God, I don't know how many motions to suppress. And, I mean, and she digs in, believe me when I tell you, my wife digs in, and she's not coming on some bullshit. And her motions are always just absolutely chock full of case law, chock full. I don't know that anybody puts more case law into their motions than my wife. So, she arms the judges with all the weapons they need in order to grant motions to suppress. And suppression is a drastic measure, because
They usually find a
oftentimes,
way around it. They can either say inevitable discovery, they would have found it
okay,
anyway through this other thing, right? Good faith, that the police were acting in good faith. You got to give them the law, that the law was concrete on this issue, and no reasonable officer would have thought that they could do what they do. So no good faith, but there's, you want to talk about loopholes, they work, both ways.
yeah, for sure.
All
For
right. So
sure.
what else do
So,
we have?
all right. So, and just like you and I had very, very little, like very little faith that either of these were ever going to be granted anyway. So, like, I certainly wasn't stunned when I read the orders. I wasn't
You
like,
mean
oh
for
my
the
God.
Franks?
Yeah.
Oh,
Like,
yeah.
there's like,
She's made it pretty clear.
yeah, she made it pretty clear. All right. So this other thing, is just kind of a preface of, kind of this filing that they filed today. And I'm talking about the defense. And this is a precipice where they're asking for some transcripts, which she granted in part. So this matter comes before the court on the accused precipice for transcript, and the court, being duly advised in the premises, now finds that this motion shall be granted in part.
So let me just explain to people. So because he's represented by public defenders, being paid for by the county, he has to petition the court for things like transcripts, where if you're privately representing someone and you want a transcript, you pay for it. So if he's asked for a transcript, I don't know if we know if there's something else specific they asked for that they didn't get, but what they're getting here should be any potential witnesses' testimony, which they should be entitled to, in order to properly cross-examine them, at trial, assuming any of them are caught at trial. So, um, so go ahead, babe. What did she?
So it's therefore ordered that the following hearings under the above caption matter be transcribed. So the hearing held on November 22nd, 2022.
Do you remember what that was?
I
Sorry,
want to
sorry.
say that was right after the arrest, and I'm assuming that this is the hearing wherein they went in to ask that the state went in to ask that the PCA remain sealed. I'm assuming that's what it is, because that was like that had to have been like one of the first court dates, or that's when they went in and got the safekeeping order. I'm not sure.
Yeah, I just don't think that the safekeeping order would be something they'd need for trial. You know what I mean?
Yeah.
But
Yeah. All right. So then the testimony of Jerry Holman and Trooper Roland Purdy from the motion to dismiss hearing held on July 30th, 2024. Testimony of Walla, Gallipo, Holman, and Brian Harshman from the motion to suppress hearing held on July 31st, 2024. And then the testimony of Holman, Purdy, Cicero, Perlmutter, who was a defense witness, Cecil, who was, like I said, he was their phone guy from the motion to eliminate hearing on August 1, 2024. So she's granted those. I don't know everything that they asked for. And I think that they had I think that we didn't do a live on it because it was like a very short filing, but I think that they had filed for, I think they wanted all the hearings transcribed, all 3 days of it. And, so the bonus is that we'll be able to get these at a reduced cost for the transcripts, because they ordered them and she had them done. So, it's like that thing with getting court reporters paid. Like that's in this day and age, like you can't look at that anything other than a gambit, to get court reporters paid on those things. Like just being able to charge per transcript, like whoever wants to order them.
Right. When everything's digital now, it's, but
yeah. All right. So that brings me to, so what I'll do is I'll go through, it's a very short motion. I'm sure you'll be happy to know. So it's 3 pagers. This is supplemental motion that was filed today by the defense. And it's the supplemental submission regarding state's motion in limine. And I don't know if Yellow Jacket's in here, but I cannot run, like I dipped out like right when Baldwin was starting to make his argument. Like at the end, it was like 8:30. I was trying to make it on court TV because I wanted to be on there to counter the murder sheet. And I'm texting the woman. I'm like, the woman that books me on there. I'm like, I have nowhere, because I was out of the hotel. I was gone. So I had nowhere where I could get Wi-Fi.
So all this is to say, Bob does not know, because I was asking him, did the defense ask the judge, can we get leave to submit some additional information in writing? Because I'm reading this and I said, well, the hearing's over. So is this like them trying to just get more evidence in, or did they ask the judge and the judge said, yeah, which sometimes they do, and it's a non-issue. So I just couldn't tell from reading this if it was something that they specifically asked the judge, hey, we'd like to put some additional submissions in writing, or, something to that effect. So,
like based on, they typically ask to do it. They typically ask for leave to file supplemental filings. So, but like I left before Andy's argument. I've heard it before. I've heard the argument before. So, all right. So comes now the defense. Oh, here, I'll blow it up. So comes now the defendant, Richard M. Allen, by attorney Brad Rosie, and respectfully requests this court take judicial notice of the record of proceedings held in the cause of November 22nd of 2022 in the Carroll County Circuit Court. In support of said request, defendant Allen states as follows: on April 29, 2024, the state of Indiana filed a motion in limine seeking to limit various forms of evidence in this cause. Specifically, paragraph 7 of said motion sought limitations on defendant's ability to introduce evidence of third-party culpability regarding the following individuals and or subject matter: A, Odinism; B, cult or ritualistic killing; C, Brad Holder; D, Patrick Westfall; E, Johnny Messer; F, Elvis Fields; G, Ned Smith; H, Rod Abrams; I, Keegan Klein or Kagan Klein; J, Jerry Klein; and then K, Ron Logan. So paragraph 2, the state's motion in limine sought to further restrict defendant's Sixth Amendment right to present his defense by way of limiting investigative records generated by former officer Todd Click and geofencing records generated by law enforcement investigators. On or about August 1 of 2024, the parties appeared in the Carroll County Circuit Court, at which time both sides introduced evidence in favor of their positions regarding third-party culpability. The court took the issues surrounding third-party culpability evidence under advisement. As of the date of this motion, no order has been issued in this regard. The defense requests that this court take judicial notice of the record of proceedings held on November 22nd of 2022, and attached hereto is Exhibit A. One of the primary issues addressed at the November 22nd, 2022 hearing was the state's request to maintain confidentiality of the probable cause affidavit, charging information, and other investigative records. 5, at different times during the hearing, the state of Indiana, by prosecutor Nicholas McClelland, spoke the following words as it relates to the potential for third-party culpability. Quote, "This is still a very ongoing investigation. Our goal is to find anyone else who was involved in this heinous crime. That is the public interest, to find anybody else involved and get justice for Abby and Libby."
So I just want to interrupt you right there before you read
Yep.
the rest of them. This
Mhm.
is what we have been, screaming about. Like, even if Richard Allen is one of the right guys, why is no one trying to continue to investigate to find the other perpetrators? And how do these other perpetrators play into this? Because for them to kind of shift gears and just be like, it was a solo gig. This was Richard Allen and only Richard Allen. It's just not true. It just does not seem likely. So obviously, I don't know if it's true or not. So this is my opinion. But when you hear these statements like these, it just brings home what we've been saying all along, that they did not think this was just one person. And they did not think this was even just Richard Allen. So where is all of that? How can they abandon that for a theory of the case that becomes a sole perpetrator? But go ahead.
Yeah, I know.
I
And
digress.
not DV put this up, and it was true. Holman, like, ridiculously, like, on the stand, testified that he thought that the first sketch, which is the pudgy, you know,
Right.
hatted older dude, clearly in his early 40s, was the same as the fresh-faced 20-year-old with curly hair. He's like, they're the same person. I've always thought they were the same person. And when Baldwin was trying to get
I
the
just think people
presser
are
in,
blind.
right? I mean, the thing speaks for itself. Like
Right.
Nick
We
likes
all
to
have
say, well,
eyes.
the thing speaks for itself. Yeah, well, that speaks for itself. Those are clearly not the same person. So, but you know, like, I mean, they're in the position. Like, we know it's, you know what it's called? It's called tunnel vision. And they're going to do everything that they can to get the conviction on the guy that they think it is, period. And they're not going to do anything that's going to interfere with it, even if it contradicts everything that they said previously. They don't fucking care. Their only goal at this moment in time is to get a conviction on Richard Allen at all costs. It matters not what they said prior. It matters not. That's the facts. That's not just Carroll County. That's not just Nick McClelland. That is every fucking prosecutor in this country. That is every prosecutor Alice and I have ever dealt with that just refuses to look at anything outside of their myopic view of the defendant that they have charged, that they're seeking to convict. That's it. There's no talking to them about it. It's one of the most irritating qualities of prosecutors in that office, is that they just won't engage in conversation, like in the search for justice. They don't care. Once they're locked in on somebody, that's it. So all the table pounding and like the pearl clutching and like, forget it. Like, that's just how they operate. Like everyone losing their minds. Like, this is
Dare you?
not what happens in every courtroom all around this country every single day. Wake up. It does. It happens everywhere. Welcome to being a defense attorney. Why do you think I'm so adamant about bitching about the Constitution, people? Just because of Richard Allen's case? No, because we've been doing this for 20 plus years and been getting our asses handed to us over and over and over. Gut punches. My beautiful little wife there, she came out of law school. I'm taking on the world. Taking on the world. And then gut punch. 20 years of gut punches, man. Ask her where she's at now. All right. Rant over. Okay. The second quote, we have good reason to believe that Richard Allen is not the only person involved in this case, that there may be other actors involved. That's why we left the tip line open. That's why we left the tip email open. The question becomes, at least in the state's mind, is it more important to release the details of the investigation to the public, or more important to keep those confidential in order for the investigation to continue and find anyone else that's responsible. Okay, so like in I'm going to read the letters that were attached from Holman and Mullen as well. They're short. And then finally, it puts the investigation in the best position possible to determine if anyone else is involved. It is in the best interest of the public that the investigation find anyone else involved. Okay, so paragraph 6. In addition to the prosecutor's comments, the state introduced Exhibit 1 and 2 attached in an effort to seek an order sealing the records. The first exhibit was a letter from ISP Detective Jerry Holman, and the second exhibit was a letter from the Carroll County Prosecutor's Office investigator Stephen Mullen. 7, in pertinent part, Detective Holman's letter sought the sealing of the record for many reasons, one being that the investigation, quote, is ongoing and fluid, end quote. 8, the exhibit created by investigator Mullen cited the matter was, quote, still being actively investigated, end quote. Investigator Mullen went on to state that law enforcement was, quote, continuing to search and seek facts and information relating to Richard Allen and other potential suspects, end quote. In this context, investigator Mullen was concerned that the integrity of the investigation would be jeopardized if the content of the investigative documents was released to the public. 9, Richard Allen has been arrested and jailed, had been arrested and jailed at the time of the November 22nd, 2022 hearing. Yet, the state acknowledged their pursuit of other suspects associated with these crimes. The state's own admissions are evidence of the existence of third-party culpability in this case. And 10, Defendant Allen requests that this court take judicial notice of the November 22nd, 2022 proceedings, exhibits entered during said proceeding, and ultimately deny the state's request to limit third-party evidence pursuant to paragraph 7 of the state's motion in limine marked, file marked April 29, 2024. So I think it's a lovely little argument. I think it's one of my favorite things that's come out of the defense's side. It's short, it's sweet, and it's accurate. And it's a convincing argument. They're using the state's own words. They're throwing all that shit that I was just talking about right back in their face, that post-arrest, that they still believe that there's culprits. I don't care what they're saying now. You have to be able to look at what they've said on a record publicly as to what their mindset truly is. As I said, now they're absolutely just laser focused, tunnel vision style on Allen, and they're not going to do anything to mess that up. They're not going to. So
go ahead, read the letters.
All right. So the letters, we'll read Holman's first. And that is, Dear Honorable Judge Francis C. Gull, I am Jerry D. Holman, a first sergeant with the Indiana State Police. After graduating the Indiana State Police Academy, I was assigned to the Lafayette District in June of 2001. I've been with investigations for several years. I was assigned as a detective in 2006, and in 2015, I was promoted to Sergeant of Investigations. As the investigation squad sergeant, I supervised the detectives' day-to-day activities. In 2016, I was promoted to first sergeant and assigned as the district investigative commander. As the DIC, I review and manage all criminal investigations at the Lafayette District. I responded to the Abby and Libby investigation to assist the Carroll County Sheriff's Department and continue to assist with the management of the investigation. It is my professional opinion the probable cause affidavit should remain confidential. There are many reasons for this. One reason is that the investigation is ongoing and fluid. New information comes in daily. All this, and this is post-arrest, okay? All of this information needs to be protected. By keeping the probable cause confidential, this will let individuals know that they are protected and can share freely without worry of retaliation. By not releasing the information, it will protect the integrity of this investigation and everyone involved, including Mr. Allen and his family. Additionally, confidentiality will help ensure that the witnesses are not harassed by the media and the social media. Since this is a nationally known investigation and has been the center of so many news stories, the interest in this investigation is widespread. Many well-meaning people have numerous questions about the investigation. Due to the many questions those well-meaning people have had in the past, many false accusations and information has been put out in the public, which has caused issues for innocent people. This also causes problem for investigators with trying to investigate the facts. The media and social media outlets have posted side-by-side photos of innocent people who have adversely affected their lives. I'm concerned that they will do the same to our witnesses, Mr. Allen and their families. This could be a heavy mental burden on them to be interrogated by so many, i.e. news media, bloggers, social media groups, and the general public. The physical safety of others is important to all of us, or important to us all. We have the duty to protect everyone involved and the viability of the investigation. If we do not protect the witnesses, other potential witnesses may have a problem deciding if they will choose to cooperate. This could harm the nature of an ongoing investigation. We do not want to impede the flow of information that comes in or the safety of others. We can protect the investigation, the witnesses, the suspect, and their family members by keeping the information confidential. It's a pretty like on bended knee plea, and it's pretty clear
And
from
they
that.
could have just relied on the witnesses needing to be kept confidential, but that's not a reason to seal anything because they can just use initials and extract,
Right. They just like I mean, we get redacted shit where they're pulling witness names off of PCs all the time. So I mean, all the time. It's like it's the standard. It's not the rule. It's not the exception. It's the rule. Redact witness names, phone numbers, information. I mean, when we get it, even as the attorneys, like initially, they'll sometimes have shit redacted for us. All right, dear Judge Gull, I'm an investigator with the Carroll County Prosecutor's Office and a lifelong resident of Carroll County. I was the Delphi police chief when the double homicide of Liberty German and Abigail Williams occurred. I served 24 years as a deputy with the Carroll County Sheriff's Department and was a detective with the department. I have never been involved in any investigative process as complicated, as intensive as this. As the court is aware, the affidavit for the arrest of Richard Allen contains information relating to the process of this investigation, witnesses, facts, and sources of those facts. This matter is still being actively investigated. We are continuing to search and seek facts and information relating to Richard Allen and other potential suspects. If the content of the document is released at this time, the integrity of the investigation may be jeopardized. This case information, accurate or otherwise, has been widely published in traditional media and social media outlets. Release of information by the media has confused and created inaccurate tips and information. In my opinion, the release of information contained in this confidential document would only serve to complicate and frustrate the process. What's going on with those like little? That reminds me of like a flaw in a typewriter when they're trying to figure out.
Sometimes when you convert it to PDF, something happens.
Oh, it wasn't nearly as exciting as I thought it was. In my opinion, the release of information contained in this confidential document would only serve to complicate and frustrate the process of gathering truthful and accurate information at this time. Therefore, I respectfully ask the court to continue the confidentiality granted to the probable cause for Richard Allen for an indeterminate time, allowing investigators to complete the follow-up process.
So Stephen Mullins doesn't mention anything about thinking that that there's additional suspects.
Right.
But what bugs me about this is what were they really trying to hide? There's nothing. I don't think in that affidavit that really. What would that have said to the other suspects? Like, how would it really have jeopardized anything?
I don't know. I mean, like you and I, when we read the thing, like we're like, okay, why was this?
What?
Why was this sealed? Like what's going on? Like,
you don't want us to see how thin it seems,
right? I mean, immediately, I was so offended by the concept that they sealed it. And again, Allison and I have been doing this professionally for a long time. We're not just people that read stuff occasionally or true crime, but I mean, we do it for a living, like read these things. So like when I read it, and to seal something is a big deal in a criminal matter. It's a big deal. Everything is supposed to be done transparently so that we can hold the government to account. That's the point of it. For us, the citizens, to be able to say, okay, what are these people up to? Like, what's going on? Let's see what they got, so that they can't creep around in the shadows doing all kinds of shady shit. We need to be able to see what they're doing. That's the whole point of transparency. That's why we have public hearings and public trials, because we, as citizens of this country, have the right to know. It's entirely for transparency and to hold the government accountable for their actions. That's why we do it. That's why I'm always bitching about it. So when that thing came out, Allison and I were like, what? Like it's like as little Woody would say, huh? What? Like, huh? I didn't understand it. I didn't understand it. If you guys aren't watching Little Woody with Jay, I just got news for you. It's getting a little long in the tooth now, but it's magical. It's like he's my favorite witness of all time. He just is.
I mean, for sure.
He's amazing. He's amazing. And Jay sent me, he dropped a new rap tune today called I Don't Recall.
I mean, they're gonna be. I can imagine they're gonna be.
Is he out there? Is he talking about the case on that rap?
But I can imagine he's gonna get examined about it, and maybe that's part of his plan. Like, you want to be asked about it because then all the world that's watching is now gonna go listen to it.
Yeah, I was. He just found out today, like while he's on the stand, after the lunch break, that his lawyer Melnick has been suspended for something that happened 5 years ago. Like he missed like a court date on a child support matter. There was some kind of big thing. Yeah, it was like.
So for anybody who's not watching the Young Thug trial, I know Jay is in here, and we've got links to his channel as well. You can catch up on his channel, and he and Bob are still covering. I don't know how much more you're going to do. I thought you had to move on to something else, but it is on day 110-ish.
110, 111. It's long in the tooth.
All right. So what do we have here?
In the tooth. All right. So I'm going to leave this to you because I know how you are about reading this.
No, you're reading it. I'm not letting anyone yell at me for being the one to tell you not to read something.
All right, so this is essentially them going in and asking for this thing to be sealed. This is the transcript from them, like going in and asking why they want it sealed. Okay?
So I think you can jump to the part where they actually are talking about stuff, because this beginning is like, this is a courtroom. People turn off your phones, decorum.
Yeah. It's where she introduces herself to everybody for the first time. She's the special judge. We're here on the record today. Let's see. Yeah, let's go to the meat. Let's go to the meat of the matter. Remain seated through the proceedings once the hearing is concluded. Blue, 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 blue. So, gentlemen, are you ready to proceed? Okay, so the Access to Public Records Act under Indiana Code requires the state to proceed under rules of trial rules. So we're proceeding under that. Therefore, no public testimony or comment is necessary, as that is only required under the Access to the Public Records Statute, Title 5. So, gentlemen, are you ready to proceed? Now, this, obviously, because of the subject matter, was a closed hearing. So, like, no one was sitting in there for this. I believe. Like, I definitely wasn't in there. So if I wasn't there, it had to have been closed. So I've only missed one hearing. And that was like, it turned out to be enough.
Well, no, because babe, she just went through that whole thing about people turning off their phones and everybody sitting down. All right. I
take it back. I clearly missed the second hearing. I didn't
Maybe this is the hearing that you missed. I don't know.
This is back in 2022, like right after the arrest. Like,
yeah.
Maybe I hadn't decided to drive to Delphi yet. I don't know.
Mm-hmm.
Okay. So, gentlemen, you're ready to proceed. Attorney Rosie, yes, ma'am. McClellan, do you want to read somebody? You be the court. Can you read it?
Okay. Yes.
Okay, McClellan, yes, Your Honor.
All right, Mr. McClellan, you may proceed.
Thank you, Judge. As the court mentioned, the state did file a verified request to keep the records confidential, and specifically the probable cause affidavit and the charging information. The state's proceeding under Rule 6, and what Rule 6 says, Judge, is in extraordinary circumstances, if the state showed that public interest would be substantially served by prohibiting access, or the access will create a substantial risk of substantial harm to the state or the other persons or the general public, or that it's substantial prejudicial effect to ongoing proceedings cannot be avoided without prohibiting access to the court can restrict access to those records. As the court said, the burden's on the state. I must show by clear and convincing evidence that at least one of these requirements are met. Doesn't have to be all of them. Just one, judge, just one. And then if the court does decide to keep the probable cause and charging information confidential, the court's required to do so in the least restrictive means necessary. So, Judge, in that effort, I've decided to present a couple of exhibits for the court to consider. I presented those exhibits to the court, and I want to go over those exhibits, Judge. I presented those to the defense. I have in court today as well. Exhibits. What's been marked as States Exhibit 1 and 2, Judge, those are the affidavits from Exhibit 1 is ISP Detective Holman, and Exhibit 2, Mullen, which we just read. They've both been involved in the case for several years, and they have intimate knowledge of the details of the case. They both believe in their affidavit that releasing information would jeopardize the ongoing investigation. The next exhibit, Judge, is States Exhibit 3, and that is a letter from Becky Patty. That is Liberty German's guardian. She is in favor of keeping the records confidential as well. And then, Judge, Exhibit 4 is an online petition that circled not only the county, the state, and the nation.
What? How does the nation have any say in this?
The nation, Allison. That's how the nation speaks.
I mean, the county, yes. The state even, okay. But you've gone a little far with the nation.
The nation has spoken, Allison. Keep it down over there. So 40,000 signatures on that petition, also petitioning the court to keep the records confidential. The state's moving to admit those 4 exhibits, Judge.
Oh, any objection from the defense?
No, ma'am.
Jody, I'll have you mark those as States Exhibit 1, 2, 3, and 4 as reflected by Mr. McClelland, please, and show them admitted without objection.
Just for the record, I want to say that you're crushing Gull. McClelland, thank you, Judge. Judge, there's not a lot of precedent for a hearing like this.
No,
I've searched high and low for case law, talked to several people. There's just not a lot of precedent.
What's that tell you, McClelland?
Situation. An extraordinary circumstances, if you will. The state is confident in the evidence that's been presented in both the probable cause and the charging information. We're confident of that evidence and of the contents, but I am concerned. I have 2 concerns: the continued investigation and then protecting the witnesses involved in that case, Judge. Those are my 2 main concerns. It's my job as the prosecutor, in part at least, to enforce the law in an effort to protect the community. It is the public interest for me to enforce that law to protect the community. The first concern talks about the integrity of the investigation. I think that falls under the public interest factor in consideration for the court. This is still a very ongoing investigation. Our goal is to find anyone else who was involved in this heinous crime. Heinous, also known as heinous. That is the public interest, to find anybody else involved and get justice for Abby and Libby. We still get tips every day. Tips come in every day. Every day. We have good reason to believe that Richard Allen is not the only person involved in this, that there may be other actors involved, and that's why we left the tip line open. That's why we left the tip email open. The question becomes, at least in the state's mind, is it more important to release the details of the investigation to the public, or more important to keep those confidential in order for the investigation to continue and find anyone else that's responsible? The public has an absolute right to the information. I don't deny that, Judge, but at what cost? This rule was designed for extraordinary circumstances where the court can limit that access. The state believes that this is one of those extraordinary circumstances. Keeping the record confidential serves the public interest. It puts the investigation in the best position possible to determine if anyone else is involved. It is in the best interest of the public that the investigation find anyone else involved. The second part that I'm concerned about, Judge, is the safety of the witnesses and other people involved in the case. We have seen the extraordinary lengths that the media has gone to in order to get the next soundbite or the next clip for their broadcast. We are a society of people that has to know right now. Social media, Facebook, Instagram. We want all the information right now, immediately. Immediately. The media has went to great bounds to interview anybody involved in this case. Mr. Allen's wife, Mr. Allen's old neighbors in Mexico. They've staked out his house. They've went to extraordinary circumstances to get anything they can, involved in this case. Even by Richard Allen's own admissions, a letter to the court asking for a public defender, they forced his wife to move and abandon their home. We also know the prior judge, Judge Diener, recused himself by his own admissions to an email to the court's judicial staff. He had concerns for his safety, for his staff, due to the fact surrounding the arrest, so much to the point where he felt it was necessary to get out of the case, Judge. And so the state believes these are real concerns for the witnesses and the people involved in this case. Look at the amount of security that we have here today, Judge. We don't have a lot of security in Carroll County, but I can tell you my tenure here, I've never seen the display of law enforcement that we have here today. This is a highly publicized case. We have countless meetings over the couple of months or past months about security, about how to get Allen in here, all for the safety of everybody involved in the case, Judge. And that should extend to the witnesses and should extend to the other people involved in the case. The court can imagine the media pressure, intimidation, and evidentiary issues that may arise if the name of the witnesses are released, and those witnesses are subject to constant harassment and bombardment by the media. The state also has concern that they may be interviewed on the 6 o'clock news, and their testimony will be taken as such. That causes evidentiary issues. Some of the witnesses were juveniles at the time. They are now 19 and 20 in their first and second year of college. They need to be able to focus on what they're doing in school and not be worried about the constant harassment from the media. And I'll remind you, Judge, some of the witnesses are still juveniles. And so there's concerns there. Again, Judge, the burden is on me. I have to show by clear and convincing evidence. And so the gauge starts at the presumption that the information should be released. And I have to convince you to move that ticker far enough to keep it confidential. And so, Judge, I looked up clear and convincing. We don't deal with it a lot. We deal with beyond a reasonable doubt. So I looked up the jury instruction for clear and convincing. The jury instruction says the facts supporting the claims are highly probable. Look at what we have here today, Judge. The chaos, the amount of attention this has drawn, the concern for safety. Defense counsel, the state, everybody has a concern for safety for themselves, for Mr. Allen, for everybody involved. We went to extraordinary lengths to protect everyone here today. We cannot look at this case like any other case. This is an extraordinary case. It is by its nature. The state believes it's important and allowed under Rule 6 to keep the PC and the charging information confidential, not only to protect the integrity of the investigation, but also to protect the witnesses in the case, Judge. So the state respectfully would ask the court to continue to keep the PC and the charging information confidential. However, if the court deemed that those items should be released, the probable cause and the charging information, I would ask the court to consider redacting the witnesses' names to protect their identity and the people involved in the case. In an effort to do so, Judge, I have redacted charging information and probable cause that I'd like to submit to the court for their consideration. It has the names of the witnesses and the people involved in the case redacted, Judge. And if the court's so inclined at this time, I'd like to at least admit that to the court, not as an exhibit, but as for consideration, for the court to consider a redacted version as opposed to releasing the entire document. The court.
Any objection, gentlemen?
No, ma'am.
Okay, thank you. I won't mark this as an exhibit. This will be my work product, so it's not available to anyone other than myself and my staff.
Thank you, Judge. So, Judge, I'm about done. I wanted to leave you with one last thing. As I said, I did a lot of case research to find any support of my motion or anything that is not in support of my motion. And I came across a case, Brown v. State, Indiana Supreme Court. It's from 1969, the year that Bob Motta was born. Doesn't say that, but it should. It's old, like Bob Motta. But I wanted to read you a quote from that case because it's kind of hit home dealing with the circumstances that we have today. And the court says this, quote, the right of the news media to fairly and accurately report the news, the right of the defendant to a fair trial before an impartial tribunal, free of influence of generated prejudice and inflamed passion of the community, and the right of the citizens to fully comprehend and analyze the administration of the court system are elements necessary to the attainment of justice. Well said. Well said, Brown v. State. If any one of these rights fall, the rest will surely fall, and the term justice will become hollow and meaningless in our constitutional system. Judge, again, the state's asking you to keep those things sealed. I appreciate the time here in court today, and I appreciate you allowing the state to have entered exhibits and to make an argument. Thank you, Judge. Thank you,
Mr. McClelland. Mr. Rossi.
Rosie. Your Honor, Rosie. Like, I am sure you will mispronounce this throughout the entire course of the proceedings, but I just wanted to let you know, Judge, you fucked up my name on the first go. All right. Thank you, Nick. Judge, let me start by just saying that Mr. Allen in this case seeks transparency. It seems to me that, in the normal course of operations in our courtrooms around the state, that's what we get. That's the norm. And there's really no reason in this case to sway from that. I would point out first, if I could direct the court to the pleading that was filed on October 28th of 2022, the verified request to prohibit public access to a court record. This pleading, if you look at it, is deficient on its face. And I would direct the court specifically to the fact that Rule 6A specifically says, quote, a verified written request to prohibit public access to a court record may be made by any person affected by the release of the court record. It requires a verification, and a verification in our business is that word is a term of art, as you know. IC 1145 codifies the very essence of what a verification is. And what you're going to find, and I would direct the court to Smith v. King. Excuse me, it's a little dark in here. It is a little dark in here. I got to fire up my light. Frankly, 716 Northeast 2nd, 963. It's a 1999 case involving an election dispute. Specifically, Head Note 3 of that case addresses what a verification is and what the minimum standard to meet that verification is.
Not a letter.
And it says, quote, when applied to pleadings, verified means supported by oath or affirmation in writing. Pursuant to Trial Rule 11B, it's sufficient if the petitioner simply affirms the truth of the matter to be verified by affirmation or representation in substantially the following language, end quote. And it says, quote, I quote, we affirm under penalties for perjury that the foregoing representations is or are true, end quote. The essential purpose of a verification is that the statement be made under penalty of perjury. And it cites Austin v. Sanders, 492 Northeast 2nd, 1986 case. This document contains no verification which references that that it's been signed under the pains and penalty of perjury. So I think it's facially deficient. And I would ask the court to consider that before we even get to the rest of this. And of course, I can offer up the case to the court, but I know you have the citation, so we should be good. Moving on. We get to the access of the public record statute, IC 5-14-3-1, open door law. All those kinds of phrases that get thrown around in our practice. And what I would say to you is that, I actually, when I look at the statute, I was actually surprised to find that the very first section, 5-14-3-1, the first chapter, codifies public policy. And I think that that's extremely rare in our practice when you actually see a statute that essentially codifies public policy. And I'm not going to read the whole thing, Your Honor. You've probably already looked at it. But the first sentence says, quote, a fundamental philosophy of the American constitutional form of representative government is that the government is the servant of the people and not their master, end quote. I mean, it sounds like something Thomas Jefferson wrote, frankly. But more importantly, you get to the last sentence and it says, quote, this chapter shall be liberally construed to implement this policy and place the burden of proof for the non-disclosure of a public record on the public agency that would deny access to the record and not on the person seeking to inspect, end quote. It says two important things. One, liberal construction, which means it pertains to many documents in our judicial system. And two, most importantly, it places the burden of proof on the state in this case, which Mr. McLeland has already acknowledged. And that burden of proof is, of course, the clear and convincing standard. So I think the point I'm trying to make here is that the legislature felt so strongly about the disclosure of public records that it actually codified the public policy. I just think that's really unique. And one of my counterparts that I practice with would say, that's pretty cool. It's just not the kind of law that we're used to seeing. So moving on, this Rule 5 is kind of the driving force here, actually, in this access to court records arena that we're in. And Rule 5 basically says that, exclusion up front that transparency up front is where the court ought to be with this. And only under extraordinary circumstances should the court deviate from that. And that word extraordinary is the second word in Rule 6 too, by the way. And what you see if you read through these rules, that there are a lot of terms that are used that are really just bolster and beef up that burden of proof. And I think that they just speak to how important it is that we have transparency in this community, in this system, I should say. And that's no different in this case. So let's get to Rule 6. Mr. McLeland hit on a couple of the bullet points, one being that the public interest is substantially served by prohibiting access. Again, another strong word, substantially. Disclosure of the records will create a significant risk. Again, a significant risk of substantial harm to the prosecutor, other persons, or the public. Disclosure will work some prejudicial effect on the ongoing proceedings. So all strong words, again, consistent with the clear and convincing standard. Let's touch on the first one specifically. Will the public interest be substantially served by limiting access? And Mr. Allen's position is no, it will not. It's exactly the opposite. This is a case where the crime occurred over 5 years ago. It's taken almost 6 years for an arrest to be made. Time and public resources have been exhausted over that scope of time. There are almost impossible to quantify, and any secrecy involved in this investigation, in my opinion and Mr. Allen's opinion, has done nothing but increase the hype and the public interest. I mean, it's the idea that the public has known very little is what caused, all this attention to occur. And so by continuing that pattern or allowing the state to maintain this confidentiality, I think that we're just perpetuating the problem. My suggestion is that the opposite would happen if you unseal the records. And that is to say that the public can see the truth regarding the facts that support the allegations in this case. They can see where the expenditure of their tax dollars has gone. And, Mr. McLeland talks about the second prong here, and that the release of the records will create a significant risk of substantial harm to the prosecutor, other persons, or the public. At this point, I don't want to sound flippant, but what's the risk? I mean, we all just walked in here today, with the security and the right safeguards in place. We're fine. I'm fine. Are you good, Judge? You good? There are just a few juveniles referenced in the affidavit, and I do understand that may play a bit of a larger role in the court's opinion today, just trying to protect those individuals. Frankly, Mr. Allen, the defense doesn't have any problem with redacting some of the names of the witnesses and things of that nature that might serve a purpose. But, I haven't heard, nor have I seen in any of these exhibits that were introduced by the state, any actual references or appreciable threats that have occurred. In other words, we didn't hear John Doe or, Jane Doe come in here today and tell you that they received a phone call from an anonymous person last week with, a threat on their life. I haven't heard an officer say that he or she has been, their lives have been threatened. I think a lot of this is just driven by the social media aspect of this. You can get on Facebook any day of the week and find somebody threatening somebody. Not that I don't take those things seriously, but it's just like fast food. Most of that doesn't have a lot of quality to it. It's just quantity. And I haven't heard any evidence today, other than some argument about the law, which actually supports the idea that there are any appreciable threats on anybody involved in the case. And so, any suggestion at this point regarding the second prong, that there will be some significant harm to the public or people involved, I think is just conjecture and speculation. Moving on, there's a practical problem here too. And that practical problem is if the court orders these records to remain confidential, we're going to be forced to walk into this courtroom and delicately dance through all the factual scenarios in this case because the public's going to be sitting behind us. And that doesn't seem to make any sense. It seems to make things more difficult. You're going to have people reading between the lines. All this stuff is going to go down in print. And then you're going to have all these, the public trying to decipher what we did and didn't say and what we're inferring. And, it makes our jobs way more difficult. I would argue that it's going to make Mr. McClelland's job more difficult. How do we talk about the law and the facts in a bond hearing? We got a bond motion pending. How do we talk about the law and the facts in a suppression hearing? How do we talk about the law and the facts in a hearing on a change of venue? All of those things, which are pretty customary in cases like this, the public would be sitting right here the whole time. So it just doesn't make any sense practically either. And I'll just finish with this. The burden again. We've talked about the clear and convincing evidence. I haven't gone back and counted. I didn't do any internet searches before I came in here today. But over the last 5 years, I have some very ingrained memories of state police press conferences in this community. I don't know if there were 2 or 4 or 6 or 8 or 10. I don't know. It seemed like a lot. And, in my mind, for the state to come in, for the state to be a part of that process of having public press conferences, releasing composites, things of that nature, and asking the public for help, and then to turn around today and suggest to the public that, quote, we don't really want you to see what's here, end quote. It's kind of like talking out of both sides of your mouth. I mean, that's the way I view it. And I think that that's the way Mr. Allen views it. Is that how you view it, Rick? Rick agrees. And, we think that the standard is extremely high here. Clear and convincing. Nick gave me a little crash course on what the Black's Law Dictionary says. What I know about clear and convincing evidence is, for those of us that practice in civil court from time to time, it's the standard that we employ when we're trying to terminate somebody's parental rights, which I think is pretty darn high. And to say that the state has met its burden in this case, I think is just not accurate. None of these documents that you have seen any information in them which suggests anything with detail that somebody's in harm's way or that some other suspect is, out there and needs to be apprehended. It's just conjecture. And we would ask that you unseal the records, if you will, for the lack of a better phrase, and let's move on with this. Thank you.
Any response, Mr. McClelland?
No, Your Honor.
Well, gentlemen, I really appreciate your excellent oral advocacy.
Wait, your mic dropped. You're muted. What did you touch?
Okay.
What did you do?
I don't know. I must have hit me. I was trying to make it bigger so I could see. Well, gentlemen, I really appreciate your excellent oral advocacy. I will take the petition under advisement to review the exhibits that have been submitted, the case law that has been argued by counsel, and issue a ruling in due haste. I know this case has generated a lot of public interest, and I know the attorneys and Mr. Allen deserve this court's attention as quickly as possible. I know with the holiday coming up, that will not interfere with my ability to review my notes and the exhibits and issue a written ruling. Mr. Rosie, you and Mr. Baldwin.
I told you, Judge.
Mr. Rosie, you and Mr. Baldwin did file a motion or a petition to let to bail. We can set that for hearing while we're here today.
Oh, hold on.
That's fine. That's fine. Oh, you need to move the page down anyway.
I gotta turn on that light. It's getting dark as hell in here. All right. It seems like it's starting to get dark earlier. That makes me sad. It's only 7:50.
Okay, so you're at yes, ma'am.
Yes, ma'am.
So that we can get the matter resolved. Are you looking at this year as well, or?
I'm thinking January. Is that?
You're thinking January?
Yeah. Yeah, that's fine, Judge. I'm out here the first week in December, and then we have a jury trial starting here December 12th. So December's kind of
okay. You went
shot from the state's perspective, Judge. So I'd be looking at January as well.
I can't see because was it
What?
just say okay? It's too high.
What's too high?
Oh, I have it blown up. That's why. Sorry.
Wow.
Sorry.
Wow.
Okay.
I think my biggest concern is just frankly giving Mr. McClelland's office some time for him to get us some of the basic discovery and us being able to have a little time to sort through it.
I was going to ask you about that.
Yeah.
I know the prosecutors indicated it's pretty much an open file discovery policy here in Carroll County.
It is, Judge. Yes. Yes, it is.
You've received what? Anything?
Well, just the PC affidavit.
Okay. So you don't have any of the formal discovery from the state of Indiana?
Yeah, I don't know what the volume is going to be like, so I don't want to get ahead of ourselves on the scheduling side. I wouldn't even have a problem, Andy, early February, even if that's reasonable, or am I? No, late January, early February. I would like some time to.
Are there any particular days of the week that work better? I'm looking the first week in February then, if that's what you are all talking about. This is my calendar for the next 2 months.
Judge, I will be in a murder trial down in southern Indiana the first week of February, so that would not work for me.
So that won't work for you. Okay. What about the second week? I'm in a murder trial every week, just so you know.
She already, even at this point, Baldwin irritates her. You can tell she's fine with Rosie. Like at this point, she's already, yeah, let's see here.
So the second week in February?
I'm more open than it sounds like than the court. Second week of February is fine with me. Not knowing how long that trial is going to last, if we're going to do the second week, I'd prefer like the 10th. It should be completed by then. I'd hate to continue it.
Okay. I was looking. So you're looking at the first full week, the 10th?
Friday?
You're saying the 10th.
Right.
I don't want to jam you up. I mean, if there's not a good day, we can go to the second week, the beginning February 14th.
I would actually prefer that because I'd like to come out of that trial and have some time to prepare for.
Okay.
Like, you're not interrupting me like efficiently. So I'm going to do it again. I want you to interrupt me in the middle of when I'm speaking. I actually would prefer that because I'd like to come out of that trial and have some time to prepare for the hearing. I appreciate it. Of course, I also have another murder trial scheduled that week, but I don't think that's going to go. So
what about February 17th? Will it take all day? Is that fair? Half a day?
I think we should set the day aside.
The day?
Just to be until we get off and running here and we have a better idea of how quick the lawyers work and that type of stuff.
Okay.
I'm okay with the 17th. Nick? That's fine. Yes.
All right. February 17th. Can we start like 10? That way my staff and I don't have to get up that early. My intent is to have as many hearings here in Carroll Circuit as possible. I have no idea what the calendar looks like for the sitting judge.
Sure. McClelland, we don't have anything on that date as of now, Judge.
Okay. As of now.
I have the court calendar. Now, that obviously is subject to change, but right now, there's nothing set for that day.
Okay. So we just set February 14th. 17th at 10 a.m. And I'll make sure that Mr. Allen joins us. I'll get a transport order. All right. I know we have an Omni hearing in January there's already been a trial setting. And it's my understanding when I spoke with the judge before, after his recusal, that the trial setting is a first setting.
That's correct, Judge.
Which
sorry to interrupt the court, when the prior judge said it, he did it as a first setting in March.
Okay.
I'd say that we just let it sit for now till we
sit.
Yeah, I mean, we're not setting aside the week yet, right? We just have the date on the calendar. So do we need to change the omnibus date to let the bond date hearing date?
I'm happy to do that if you'd like. Would that be easier for you?
I'm happy to do that if you. Oh, is that what you said? Oh, yeah. I think that makes sense, but I would. Yeah, I think it's a good idea.
Okay. So cancel January 13th and we'll do it February 17th as a bond hearing and an omnibus hearing. And that's satisfactory to counsel, Mr. Rosie?
Yes, ma'am.
Okay. Is there anything else that needs to go on the record, Mr. McClelland?
I don't believe so, Judge. No, nope, nope,
Mr. Rossi?
nope, Rosie.
Rosie. All right. Thank you, gentlemen.
Thanks, Judge. You're awesome. You're
I
awesome.
appreciate your advocacy.
Thank you. I appreciate your awesomeness, Judge.
Ladies
Take
and
care.
gentlemen, as I indicated, if you would all remain seated until the parties and Mr. Allen have been removed from the courtroom.
Fini. That's it. All right. So there it is. All right. So that's all of it. That's everything. So.
And then she ordered it released, or she had to be forced to release it. I can't remember.
She ultimately released it, but it didn't come out until like
Your coloring so weird because of the lights.
Mine is?
At least to my eye, you look
insane. Yeah.
No, just like
pretty bright.
Looks like you're in candlelit.
It does still?
To me.
Oh, it's like it's blinding me. So I mean, end of the day, I think it's a pretty compelling argument. The question is, and it was kind of the first thing that you asked, and we talked about it early in the live, and we're going to kind of end on it, is she going to, did they get leave to file something supplemental? Or is she going to be like, you didn't?
Somebody did indicate earlier that that was something that was discussed and that they did get some kind of leave. I put it up while you were reading it. I'm never going to find it again, but
yeah. All right. So, I mean, for me, I look, the reality is there's like, I will be stunned if she prohibits all talk of third party culprit. Like
I mean, I don't know how she can get around the argument that there was a lack of investigation, even if it doesn't rise the level of 402 evidence, like other bad acts or something specific like that. But to indicate that there were lines of investigation that were left open, or that the timeline's in doubt, and that there was this whole other investigation that occurred. I don't know how they get around that. They're going to get on evidence of the investigation. They're not going to talk about that line of investigation. I don't see how how they could bar the defense from at least even asking those questions about, well, you investigated this person, there was this other officer, they investigated, I don't know though.
I don't know either. All right.
But if they severely cut their legs out from under them, I can guarantee, well, I would assume someone's going to be ready with a writ.
Yeah. Attack the timeline. That's what you do. Attack the timeline in this case. That's the key to this defense. Not the third party culprit stuff. Attack the timeline. I'm on record saying that. That's if you and I, if this is our case, we're attacking the timeline, like full blown, full frontal attack on the timeline in this case.
I mean, you've gotta hope they actually have it. Like we've been saying, if they've got his phones, I'd expect to be seeing evidence of like what he was doing on his phone.
I mean,
maybe, but there's always the possibility that he was doing nothing because he was involved.
100%.
So
100%.
we're just.
I mean, we've heard jack shit about Rick Allen's phone ever. Nothing from either side.
Right. And if there was that, considering all the other things that have been put in, I mean, again,
that's what I'm saying. Like if they had some kind of smoking gun evidence from the state side on Allen's phone, we certainly would have heard about it by now.
But vice versa. I think if there was, well, he was doing X, Y, and Z until this time, and then he was doing this, and then he was doing that. They had his phones, or they had access to the phones, or whatever the case may be, and they didn't tell Your Honor that he was clearly, predisposed during these time periods, and then he was driving, and then he was thising, and then he was thating. I mean, I don't know. Yeah,
I know. So and like the kind of the final thing I want to talk about, because I'm going back on with Dorsch in like an hour, so I'm going to wrap this. is this hearing on the 23rd. So like it's set for, I don't know if I pulled up that order. It's a weird order. It's like, did you send me that order as well?
Yeah, that was the first order I sent you. It's a text. You can pull it up there.
Wait, it's a text?
Well, you want me to pull it up?
Yeah, because I told you my Apple ID on my computer and my phone are two different things. I can't get my text messages on the computer. It's not a thing. It's not a thing for me. Can't do it. Can't do it.
All right, I'll share this. It's very, very short. I could just read it, but I'll share it.
Yeah, it's interesting to me because it's a status and explain like a status hearing. Because I immediately when I hear like people like, oh, he's pleading out, I'm like, oh my god, like that. Like a status hearing is typically you're coming into court. They're typically in a normal case, you have a status hearing every 30 days, and it's exactly for that, for the sides, both sides, to tell the judge what the status. This is where we're at in discovery. This is where we're at. We're still waiting on Cecil's report.
We might be filing another motion. We're going to need some hearing dates coming up.
You're giving the judge the heads up on what the hell is going on in the case, you know, and like people just like, oh, this is the day he's going to plead. I'm like, well, I don't know, man. That's like, and like convinced of it, convinced that this is pleading day. Rick Allen's pleading out today. It's happening today.
Babe, read it.
All right. Well, you read it. It's bigger for you.
The court orders this matter set for status hearing on August 23rd, 2024 at 1 p.m. in Carroll Circuit Court. The first portion of the hearing is closed to the public. The second portion of the hearing will be open to the public. Court to notify. So clearly they've had some discussions by and amongst themselves about what they're going to be discussing during this first half, and the fact that it needs to be outside of the public. I don't know why they don't just do it, in chambers and with the court reporter, and then come out for the public part. Or I don't know, maybe it's their public records law that requires them to, because there's, and maybe they don't really do that in Indiana as well. So
yeah,
but they're clearly going to discuss something,
right? Which, like, if he was pleading out, they would 100% make sure that was public. Like they're not doing that behind closed doors. That's like, if the dude, he's not pleading out. They're not removing Baldwin and Rosie from the case. Those two things.
None of those things are happening. What makes people say those things are happening?
Every dime that I have on both of those things, neither one of them is occurring.
Who is saying those are happening? Just like the interwebs?
Yeah, the interwebs.
Wow.
Like I've seen creators like the torch and pitchfork get before trial without seeing the evidence that Allen's the guy and he's got to burn in hell and all that other shit. This is the plea day. He's finally pleading because they have such powerful evidence against him, and that's it. It's over. Which would be weird considering they just spent 3 days in court, the lot of them, like 2 weeks ago or whenever the hell that was. Look, sometimes you go through the motions, and if you lose them and they know something we don't know about these confessions, and like if there's really somehow that he said things that nobody else would have known, or whatever you said occurred, that at least the cop said in his estimation, whatever he said is something that somebody with intimate knowledge would only know. It's always a possibility. It just doesn't seem like that's where this case is going. Oh yeah, this dude, this sleuth intuition is like just convinced that it's plea day. It's plea day.
That's a person, sleuth intuition.
He's a dude who's got a channel.
Okay,
he's like, he's convinced that Allen might absolutely might be the guy. Like I have no idea. It's like despite what everyone from the murder sheet thinks, it's like I have no idea what the evidence in this case is. So like it's nice to know that I got up in people's heads like that. And I had a little bit of an impact on the way people think about criminal cases, which is really the goal here, kids. So DB was asking, plea negotiations about facts of the case happen all the time in open court? No. Like they're like plea negotiations don't happen with the state, the judge, and the defense attorneys. Like, I mean, if you have if you're going to have a conference with the judge in chambers, you know, I mean, it's got to be, tell them about those when we do them, babe.
Well, typically, if the judge is getting involved in some sort of plea negotiation, well, in Illinois, the state has to agree first and foremost. And then basically both sides sort of pitch their facts to the judge, and the judge says, well, I'd give him
And that's always
20
back in
years.
chambers
Right.
outside the presence of our client.
Right. I'd give him 20 years, you know, so then you can go to your client and be like, well, the judge is at like 20 years, you know. And sometimes we do that when we think that we can get the judge to help make the state be more reasonable, or we can convince the judge of something the state hasn't taken into consideration. Or sometimes the state sort of does it so the judge forces their hand, so it's not just their unilateral decision. And they can go back and be like, well, we had a conference and this is what the judge said. So there is absolutely no chance that what they are talking about in chambers is I would be the facts dealing with like a plea negotiation, because you don't really deal with the facts in a case like this. I mean, either he was in any way, shape, or form involved in the death of these little girls, or he wasn't. So it's not like a factual thing. And sometimes we do in our plea negotiations with the state say, well, look, my client's not going to admit all of that, so you're going to have to adjust your version of the facts for the purposes of what we're going to say at a plea hearing. And as you know, you I lost my train of thought.
Well, look, the only thing I'm going to say about it is, like, typically we're getting, we're going to do one of those conferences where we're talking about potential sentencing to try to get an idea from the judge. And like, sometimes we want the state to hear it. Like if the state is just not moving off a position, off a year, like we're like 8 years, 10 years. And we're like, let's go back. Let's have a conference with the judge. Let's talk about it. And at that point, the judge will say, okay, both give me your pitch. Like, what's the case? What's, like, give me some.
Right. What's an aggravation? What's in mitigation?
Right.
And then they come down, with a.
And the judge will say, and like, if it's lower than the state's been coming, sometimes that will convince the state to move their number. If not, if like we're looking to plead our guy out because the evidence is like so intent that it's going to end up in a conviction, that we're not going to win it at trial, and we can go out and we can say, all right, look, the state's not going to move off that number, but we had a conversation with the judge, and this is kind of where the judge is saying that they would land. So, and then at that point we can do what they call a cold plea, which is where we reject the state's offer and we go straight to the judge and say, Judge, we're going to have,
you plead guilty without any sort of negotiated sentence, and then you go to the judge, go to a full sentencing hearing with the judge.
Well, not always.
Well, I'm saying if you did a cold plea.
Yeah, like, I mean, like, if I'm doing a DUI, I'm not going to a full sentencing hearing. Like, I would do cold
well, whatever your version of a sentencing hearing is for that, right? That wouldn't be, much.
Right. Yeah. Very, very limited. So look, it's not happening. Like you have it on good word here that people who actually practice law, like, a status hearing is not going to be Baldwin and Rosie being removed from the case or Rick Allen pleading out. I got news for you. This thing's going to trial. Like, it's whether or not it's going to be October, I don't know. I think it depends on when they get this new Cellubrite extraction thing from Cecil, and if it gives them enough time to get it to their expert to be able to figure out what's what with it. Because I'm just telling you all, like, I'm aware of the 61 confessions or more, and those are a huge, huge problem for the defense, especially in the eyes of a jury. Like, a jury,
yeah, it's like, that many. I mean, I know I've been saying, like, I want to hear them before I say anything, but that definitely had an impact on me.
Huge number.
Right.
It's like he was either just off his rocker or he killed the girls and they had to come to Jesus moment. It's one of those two things.
Or
like
both.
We know that he was going through some severe mental issues and mental health problems, and that he was in a like pre-psychotic state. Like that.
Right,
that's
even
all
if
true.
you're psychotic, it doesn't mean that you'd necessarily be confessing as a part of that. Now, I didn't know what you mentioned to me today, that the psychologist was saying that he was getting pressure, or people were doing things to him or saying things to him.
Yeah, people were fucking abusing this guy all the time, telling him to hang himself and to do that, like, you're child murderer. And we have no idea what these guards have been saying and doing with this guy. Oh, thank you, Pam. I appreciate that.
That's very
Our
sweet.
first $5 holler of the night were dollar or hour 40 yen. First super. You're amazing, Pam. You're my favorite, Pam. Thank you. My favorite, Pam.
Stop.
Just super. A lot of work. All right. And I'm coming back. So, y'all, I have portaled you because wake up to Ronaldo Guevara. There's other cases aside from Delphi out there that you should take an interest in. This guy was the worst cop ever.
And regardless of when he stopped being a detective, I can tell you this much: there are still people today trying to get their cases looked at. And
they're like somebody last month was just exonerated. Like they're paying out 20 million. This guy put 50 plus innocent people in prison on murder beefs, convicted. It's an unbelievable story that everyone should know about. It's frankly, when Margaret Burns' thing is on Netflix, y'all are going to be on the interwebs like, holy shit. And I'll be like, yo, I was trying to tell you about this a year ago. So I've portaled you in, maybe hang around for it. It's at 9:00. After that, I've portaled you to my homies, Publicly Buzzed. They're doing the amazing Phil Spector trial where Alan Jackson was the prosecuting.
So how much time have you given yourself with between those two?
Like no time, like 20 minutes, like 30 minutes to try to put some food in my belly. And
no, I mean from when you start the live until Publicly Buzz starts.
What do you mean?
The time between your
live. I keep it
Bill.
about an hour with Bill, like on the nose. Like that one, I shut Bill down. Plus, it's like 3 a.m. for him. So
hey, don't given times might tell people where he's at.
So he's an undisclosed nation somewhere over in Europe. All right, so we love you guys. Thank you so much for hanging. We will see you on the next one, which with me. Oh, tomorrow, Dizzy has just told me that they have impaneled a jury in the Robert Tellis trial. We will be streaming that. My beautiful wife will be joining me. No, on our channel.
No? Oh.
Jay's got to do shit every day. We're doing Tellis. I think he's going to still be doing Woody. So that's going to be something that's going on with him over there. And it's a Vegas case. So they're Pacific time. So I think Dizzy said, I'll change the time. I've got it. It's 12:30 Central Time is when that case starts. So they're starting trial. The trial is going to start at 10:30 in the morning Pacific time, which will be 12:30 for us, 1:30 start time for East Coast. So keep an eye out for that. Hope to have you in there. It should be a super weird, crazy trial with a public official that just apparently lost his shit and killed a reporter who
allegedly, sir.
That's what I said. Allegedly lost his shit and killed a reporter. Or I said purportedly. I said one of the two. Now, I feel pretty good about this guy. I feel like they got the right guy. They got some pretty powerful evidence. He's got they planted all the evidence theory. So it should be an interesting one. So, all right. I love you, babe. Mods, thank you so much for hanging. And if you're going to hang with us tonight, I doubly, triply thank you for hanging with us even later. And all you guys for hanging with us. Thank you so much. If you like the channel, please subscribe. Like we've been stuck at 23, just went over 23.2 for a hot minute. subscribe. Like, we put out pretty good content. We put some actual knowledge out into the world. So we'd appreciate
don't
if you
forget to hit
share,
thumbs up
subscribe,
because
and a like. Yeah, whatever gets us out
let's
into the
see,
algo. I have no idea.
we're at
Thank you,
315
Gigi.
thumbs up, but there were 600 and some people here.
Yeah, it was
So
like six, the high sixes. So
don't forget.
yeah, love or hate us, subscribe, and you should love us because we're lovable. And we're really trying to educate you. We spend a lot of money on our law school education, so we give it to you guys for free. Talk to you later.
Thanks, Gigi.
Love ya.